Assalamualaikum warahmatullahi wabarakatuh. I bid to Miss Siti Hajar binti Muhammad Hussein. My name is Muhammad Farharis. Together with Nur Syamimi from Group 10, will explain to you about the case that we have reviewed. The award case that we decided to review is the case between is breach of contract by the employer. The second one is the breach must sufficient to justify the employee resigning. The third one is the employee must leave in response to the breach and not for any other unconnected reason. The last one is the employee must not delay. The employee should leave as soon as possible. So now that we know about constructive dismissal, let's move on to the case. So the company in the case before the court is a public company listed in Bursa Malaysia and located in Petaling Jaya, Selangor. Through the offer of employment letter dated 18th of June 2014, the company has employed the claimant to work with the company in the position as Assistant Procurement Executive cum Warehouse Assistant with a monthly salary of 2,500 starting 18th of June 2014 with Executive rank E10 category. Through a letter dated 25th of September 2014, the claimant has been confirmed in his job after being placed within a probationary period of 3 months, and simultaneously with the confirmation of the post, the claimant's monthly salary has been increased to 2,600 effective the 1st of October 2014. Through a letter dated 16th of February 2017, the claimant's monthly salary was increased by the company to 3,500 effective the 1st of February 2017. Other terms and conditions of the claimant are maintained as before. The claimant's services in the company were terminated by a letter dated 27th of May 2019, which was signed by the director of the company, Noel Joseph Hartien Sen, on the grounds of termination of business activities, effective 31st of May 2019. Through his pleading, the claimant has pleaded that his termination of employment was unfair on the grounds that the termination of the work was made abruptly and the company failed to provide an opportunity for the claimant to make preparation. So, the claimant has applied for an order for reinstatement without losing any interest and or any order deemed fair and just. It is a strict law that in hearing references under Section 20, Industrial Relations Act 1967, the first thing that the industrial court must do is to question itself the question of whether there is a dismissal, and if so, whether it is with or without fair cause and reason. The issue to be decided by the court is whether there is a dismissal, and if so, whether the dismissal is for a just cause and reason. It is clear from the record of the proceedings, this case was cancelled due to the absence of the company, the absence of both parties on 9th of March 2020 through a cancellation award number 613 of 2020 with the freedom to revive within a period of 60 days from the date 9th of March 2020. Okay. However, at the request of the claimant, this court has revived this case and included it in the list of causes through award number 1166 of year 2020, and has set a trial date of 9th of October 2020. the court should state for the record that when the case was called for hearing on 9th of October 2020, the claimant had appeared in court and was ready to testify orally. However, the company was not present on that date, which has been set for trial for the case before the court. The company is also not represented by any solicitor or representative from the Federation of Employers Malaysia. And the claimant represented himself during the trial on 9th of October 2020. Based on the background of the case, the court has
claimant the case statement that has been filed by him and taking into account Section 30, Subsection 5, Industrial Relations Act 1967, which require the court to act according to equity, good conscience, and the substantial merit of the case without emphasizing on technicality and legal form. Next, I will explain about the recommendation. One of the recommendations that we come up with is that the defendant has to attend the court that is pre-trial case management before the trial begins. On the hearing that pre-trial case management or PTCM is held, there is several situations on the hearing that pre-trial case management that the defendant has to overcome, such as the court will call the parties to come to the court, the parties compile all documents, and identify the witness. The court will inquire the issues, document, witness, and give direction to what document has to be filed. This action is made by Ismail bin Abdullah because their company, that is YFG Berhad, did not attend the court. If the company had attended the court, this claim from the plaintiffs could be discussed and solved. The second recommendation is the defendant has to ensure that the change that they make for their company does not affect their employees, its harness, and for legitimate business reason. In this case, the company did not state earlier before their company terminate Ismail bin Abdullah. The plaintiff filed the case because their company failed to give a notice to terminate his contract according to the notice period stated in the contract. Section 20 of Industrial Relations Act provides machinery for dismissed employees to make claim for reinstatement if they believe their dismissal to be without just or excuse. Such claim, if not resolved to conciliation or arbitrated by the industrial court, which has repeatedly said that dismissing an employee without a proper reason is not acceptable in Malaysia today. Not only the reason for the dismissal the reasonable, but the procedures follow prior to the dismissal should be fair. The third recommendation is the company should talk to their employees prior to implementing a significant change. The company has to explain in detail the legal reason why their company has to close and have to terminate their employees. The employees will know the reason and cannot take action to their old company. The employees must know the actual reason why their company has to make change in their management, position, and others. The company has to keep giving regular communication about the changes to the employees. The fourth recommendation is the company has to confirm the change in writing and get the employee to sign off on the change. If employee agreed to the change, the company has to provide a new consideration in exchange for the change. With the employee consenting to the change, it's no longer unilateral. The change of employment must be written in document. The written document must be sent earlier to the employee so that the employee can get ready after they have forced to terminate and other matters that concern with their employment. Another recommendation is YFG Berhad need to make unilateral and substantial change. They have to provide their employees with reasonable notice of the change. The reasonable notice has to be the same notice that they have given to the employee that have been terminated from their employment. The notice must be given to the affected employees at least 30 days from the employee termination. If notice is given 30 days prior to termination, this will ensure that the employees cannot file the case to the labour court, or employees do not need to report or take action from their termination. Next recommendation is YFG Berhad must ensure the employee employment agreement include all terms that provide with the right to unilaterally change certain essential terms. This solution is to reduce and avoid the employee disagreement on wages, salaries, benefit and also demand. For example, YFG Berhad must include terms that authorize and contemplate transfers, change in duties or change in pay structure at the beginning of the employment contract. This way can help protecting the company from getting constructive dismissal claim from their former employees. Lastly, every company should always treat their employees with honesty and in good faith. For this case, YFG Berhad will not be honest with Ismail bin Abdullah as their employee because they did not inform Ismail with notice prior to his